ADR, or also known as alternate dispute resolution, comes in three forms: negotiation, mediation, and arbitration. It's typically used instead of going to litigation because it's generally faster and less expensive. Going to court is a long, lengthy, and expensive process that requires a lot of time and effort. Today, we will be discussing each of these forms of ADR, as well as why and how they are used. Negotiation in the context of ADR is an informal class of problem solving. Parties involved in negotiation freely discuss their ideas between each other without involving a third party. This form of ADR is almost always used before attempting mediation or arbitration. The main advantages of this form of dispute settlement is that it allows the parties themselves to control the process and the solution without formally involving the court or a third party. It's the fastest and cheapest form of ADR, and it doesn't require experience to participate. This form of ADR is used every day in every facet of life. Roger Fisher and William Ury wrote in their book, Getting to Yes, Negotiating Agreements Without Giving In, that any method of negotiation may be fairly judged by three criteria. It should produce a wise agreement, if agreement is possible. It should be efficient, and it should improve, or at least not damage, the relationship between the parties.
Mediation is a step up from negotiation and is often referred to as assisted negotiation. This form of ADR involves a third party who is completely neutral, known as a mediator. Their job is to talk to each of the parties and help them reach settlement. Generally speaking, mediators are highly proficient with their negotiation tactics and exceptional communication skills. This allows them to help the parties in the dispute reach a solution. The mediator's job is to freshly make sure that each of the other parties involved act in good faith and to make sure that things are done smoothly. This is usually done by making each of the parties involved sign what is known as a mediation agreement. The benefits of this form of ADR is how quick and cheap it is when it is compared to litigation, in addition to helping the parties who struggle with communication to receive professional help. Mediation does come with its downsides, as both parties need to participate voluntarily and aren't legally bound to commit. Later on, one or more of the parties may come to the conclusion that mediation was not the best path and want to move forward to either arbitration or possibly even litigation. Mediation is used when the parties involved cannot come to a solution that is satisfactory without the help of a neutral third party. The mediator may even have solutions that the parties couldn't even come up with themselves. Since mediation is formal and has fees involved, it is typically only used by businesses. For example, when a company has done a wrongdoing to employees or a customer, to make sure that the dispute is settled as smoothly as possible, they use this form of ADR. Our final form of ADR is arbitration. Comparisons between arbitration and traditional litigation or a lawsuit are frequent. To some extent, these comparisons will depend on the perspective of the individual or company involved. However, in general, arbitration is often viewed as a more streamlined and less expensive method of resolving a dispute between two parties. This form of ADR requires a mediator or a third party and is occasionally court-ordered. Mandatory arbitration clauses are common in contracts, and such clauses are enforceable against the parties even if they wish to litigate their claims. There are many benefits that arbitration has to offer when compared to litigation. The proceedings are typically not part of the public records and may not have more streamlined procedures and rules. For individuals who seek to resolve their disputes quickly and keep the details private, these considerations may prove to be valuable.
If there's anything that you should take away from this video, it's that ADR stands for alternate dispute resolution. It consists of three distinct methods of dispute resolution outside the litigation process. ADR is often faster, less expensive, and more private than litigation. For these reasons, ADR is often the preferred dispute resolution method. Some types of disputes are not best resolved using ADR and may be best sued through litigation. Situations where parties have unequal power, resources, or civil rights violations. The different types of ADR are negotiation, mediation, and arbitration.